Yeah, we started recording. Hi, my name is Jarnej. I come from Sindikat Mladi Plus, which is a youth union here in Slovenia. We are partners in this project that after me Maja will present. As also probably Maja will say, we are big fans of Ben and his gig economy project. So if you want to know more about the topic of platform work, join his newsletter and follow him. And I am very pleased that we have such an all-star group of presenters, which we will know, but every one of them did amazing things for workers in platform work. And maybe to finish this introduction, I think these small victories are very important, and also big victories, because they kind of give optimism for maybe something even better. So I will now give the space to Maja Breznik from Peace Institute to present the project, what we already done and what's the point of it, and then we'll start with the roundtable.
Thank you. Our project leader, Maja Turunšek, is on sick leave, so I have a pleasure to welcome you on behalf of our research team engaged in the project, The Future of Social Dialogue in the Platform Economy, the case of Slovenia. The project addresses two problems. The first concerns the weakened bargaining power of workers, and the second, the erosion of workers' rights. In partnership with the Association of Free Trade Unions of Slovenia, the project examines how platform management practices, worker strategies and aspirations, and state regulations intersect in setting the wages and working conditions. Therefore, your experiences with organizing platform workers and running campaigns for workers' rights is most precious for us researchers, as well as the trade union of delivery workers in Slovenia. Labor platforms undermine the labor law and collective organizing as we practiced them until recently. However, this must not be the moment of desperation, but the challenge to assure autonomy and freedom to workers, the autonomy and freedom platform companies promise, but not delivered. I will now stop here and will give the word to our distinguished guest speakers. And I'm looking forward to our discussion.
Thank you, Maja. As Jarnej said, my name's Ben Ray, and I'm the coordinator of the Gig Economy project. It's a media network for gig workers in Europe. You can access it at the website braveneweurope.com. I'm delighted to chair this event today on platform work, organising methods in Europe. And we've got, as Jarnej said, three great speakers. I'm going to introduce them. But first of all, I want to say a little bit about two recent developments, which hopefully can provide a little bit of context for this discussion. The first is that last night there was a deal agreed, a provisional agreement between the Council of the EU and the European Parliament on the Platform Work Directive, which I'm sure everyone here knows has been a kind of long-running saga of negotiations, compromises over the past 2 years. So I want to say a little bit about what we know about that agreement, and apologies, what we know about that agreement, and give my analysis of what we know and what we still need to find out. So the agreement basically includes the following: that at least 2 out of 5 indicators, not criteria, is an important distinction which I'll explain later, but indicators are required to trigger a presumption of employment in the platform economy. They say at least 2 out of 5 because it can member states can introduce more indicators if they wish. That's one of the important compromises to understand in this agreement. So the 2 out of 5, as I understand it, because we haven't seen the full text yet, apparently it's going to be weeks until we see the full text. But the 2 out of 5 is based on the European Commission's initial proposal back in December 2021. And those 2 out of 5, just to remind you of what they are: number 1, effectively determining or setting upper limits for the level of remuneration. Number 2, requiring the person performing platform work to respect specific binding rules with regard to appearance, conduct towards the recipient of the service or performance of the work. Number 3, supervising the performance of work or verifying the quality of the results of the work, including by electronic means. Number 4, effectively restricting the freedom, including through sanctions, to organise one's work, in particular discretion to choose one's working hours or periods of absence, to accept or to refuse tasks, or to use subcontractors or substitutes. And number 5, effectively restricting the possibility to build a client base or to perform work for any third party. Now, we don't know if that's the exact wording of this deal because it's not been released, but we have been told that it's been based on the European Commission proposal. So it's probably going to be something like that. Now, it's important to stress here, and lots of labour law experts have made this point about the indicators or the criteria, that what the platforms can potentially do is whatever indicators or criteria comes forward, they can adapt their model or tweak their model to try to not fit within those indicators, to try to avoid them. And that is the risk, that because these indicators have been established, they could potentially be worked around by the platforms to avoid triggering the presumption of employment. That is why the European Parliament had proposed a general presumption of employment, which didn't have indicators, because they wanted it just to be that a labour inspectorate would go out and carry out an investigation, and based on their analysis, based on the current jurisprudence, they would find that the workers either are or not bogusly self-employed. So the indicators are, I would say, a compromise by the European Parliament, but it's also, I guess, a compromise by the Council side, because they wanted 3 out of 7 criteria rather than 2 out of 5. And the more criteria you have, the less likely it is that you'll be able to trigger the presumption of employment. So there's been some compromise on both sides, but of course, when it's at least 2 out of 5, when member states can introduce more criteria, it opens up the possibility of having, depending on what governments in power in different countries, having a kind of unevenness across Europe, of having some countries with much more criteria, some with less. So that's the state of play with the criteria right now. Some other things that are important to know about the agreement is it includes the switching of the burden of proof. So currently, it's upon the platform worker to prove and to go to court and prove that they are they're employees, not self-employed, and the requirement will be on the platform to have to try to prove that in following this directive. How that works in practice is not exactly clear, and the details of that will be important, but that's certainly, in the press release they've put out, it's very clear that the switching of the burden of proof is part of the agreement. There'll be a prohibition on robo-firing and automatic suspensions. Basically, there'll be no automatic decision-making to suspend or fire platform workers. We don't know all the details of the algorithmic management part of the proposal, but those are 2 things that were in the press statement. They won't be able to process certain types of personal data that they hold on platform workers. And on intermediaries and subcontractors, the press release states that they will be held accountable, that subcontracted platform workers will have the same rights as ones that are directly employed by platforms. And that's for many countries like Germany, like Croatia, where subcontracting is an important part of the gig economy and food delivery sector and things like that, that's an important issue. So we don't know yet whether this is a provisional agreement. It's important to say that. So we don't actually know yet whether this is what the final, whether the council and the parliament will vote. They need to vote and to ratify the agreement. Now, it's a foregone conclusion that the parliament will ratify the agreement because the vast majority of the parliament have already indicated that they support this agreement. The two groups that were potentially not going to support it, from the left group in the European Parliament and the Green group, they've both indicated this morning that they are going to support it. So the Parliament will almost certainly vote in favour of this agreement. But it's not so clear that the Council, and remember on the Council you need 2/3 of member states to vote in favour of the agreement. It's not so clear that they are supportive of it because this has been negotiated by the Spanish presidency, and the Spanish government is probably the most in favour of a presumption of employment in the gig economy out of any of the EU member states. And my understanding is that what they have negotiated, they haven't got a sort of verified mandate from the member states to negotiate that agreement. So that vote will be on 20th of December in what's called the Coreper, where the council takes the vote on these issues. And that will be sort of decisive as to whether this agreement will actually be fully ratified. Now, what do I make of it? I guess I'm speaking to trade unionists here. Some of you would have been at the European Trade Union Confederation conference in Madrid back in September. And at that conference, the Confederal Secretary of the ETUC, Ludovic Voet, spoke about this, and he said that any criteria would be a big problem, that there should be a general presumption of employment, and whether it's 3 out of 7 criteria or 2 out of 5, it would be a big problem for triggering the presumption of employment, and could even block workers from doing what they do today, which is going to court and winning their right to be considered an employee through the courts. This criteria might block that. Now, I've just listened to, before this event started, I just listened to a press conference from Elisabetta Galmini, who's the rapporteur for the European Parliament for this directive. And she insisted at that press conference that the indicators, and she said they deliberately called them indicators rather than criteria, because they are only intended to provide a hint to labour authorities, to other bodies, other competent authorities, that there might be bogus self-employment at this workplace, whether that's food delivery couriers or whatever. And the indicators are simply the trigger for the process to establish someone is bogus self-employed. Ultimately, that will be decided by a judge, she said. So she tried to play down the role of the indicators, but I've spoken to labour lawyers. The position of I've listened to the position of the ETUC, and they were much more firm that the indicators are a problem, or will be a problem for triggering the presumption of employment. So I remember after the European Commission proposal, Will Shu, the CEO of Deliveroo, he said to a meeting of investors that he doesn't think the 2 out of 5 criteria will be a problem because he doesn't think Deliveroo meets the 2 out of 5 criteria. So there's a lot we still don't know, basically. There's clearly good things in this directive. There's a lot we still need to find out. It'll be a few weeks apparently until we get the full document, but hopefully that gives people a kind of general understanding of what was agreed last night. Apparently the negotiations went on for 11 hours, so they're quite long. Now, I've also been asked to say something about the national riders' strike in France, which took place on the 2nd and 3rd of December. So I'm going to give a very brief overview of that, and then we'll get to our speakers. So the strike was over a new pay system introduced by Uber Eats, which unions said led to pay falling 10 to 40%. It was introduced at the start of November. And the interesting thing about it was introduced on the basis of justifying an agreement between a very small union, which you can maybe describe as a yellow union, and the platforms for a minimum wage per hour of activity, i.e. not including waiting time, of $11.75. So Uber Eats, when they announced their new pricing system, said, we are introducing this new pricing system to honor the agreement. So they made it seem like this was going to be a good thing for workers, but actually it's led to lower pay for workers. And that agreement was negotiated in France with something known as the ARPE, which is a kind of system for social dialogue, and it's the French government's alternative to employment rights for gig workers. So this strike is important because it was kind of resisting this system that's been set up by the French government, and also because of the numbers of workers who participated in it. There was thousands of workers in over 60 French towns and cities who participated in the strike. It's definitely one of the biggest strikes in the gig economy and of food delivery couriers so far in Europe, and it's been a real challenge to the platforms. Interestingly, after the strike, the platforms have said they would be willing to negotiate over pay through this ARPE system. So that's, I guess that's a win in and of itself, that the platforms have had to accept the need to negotiate with the unions over this issue and take what they're saying seriously and take the strike seriously, because the unions have threatened more days of strike action. In the first day of that negotiation, two of the unions who organised the strike walked out because they said the platforms were using delaying tactics. They didn't really want to discuss the issue of pay seriously. So it's not totally clear that the platforms are serious about negotiating over pay. But even the fact that they were brought to the negotiating table, I think shows that this was a very strong strike, and it shows that it is possible to organise food delivery couriers to have powerful strikes in this sector, because lots of people have doubted that can be done. But in France, that strike, I think, shows that it is possible to do that. Okay, I'm going to leave it at that, and I'm going to introduce our speakers for today. Hopefully that provides a little bit of context for them. So first we have Anne Dufresne, who is a gig economy researcher and activist in Brussels, Belgium, and Anne works at Grecia, a research group for an alternative economic strategy. She organised the first European Assembly of Food Delivery Couriers in 2018, and is co-author of App Workers United, The Struggle for Rights in the Gig Economy, which was published in 2021. And I think Anne is going to talk about that pamphlet that she published in her speech today. Thanks, Anne.
Yes, hello everybody. I think I have to share the screen. It's okay, or is it? Do you see it?
Not. Yeah, now we see it. Yeah. Okay,
perfect. So yes, so thank you for the invitation. Thank you, Ben. Thank you, Vladi, Sindikat Mladi Plus. So yes, I will speak about the challenges and prospects I can see since the first European Assembly of Couriers in October 2018. So my structure. So is I will speak about the two strategies to tackle naked labor. Yes, I mean, naked labor for me is work without any rights, like the work of drivers or riders, actually. So the first strategy is collective actions. And the second one, legal action. I won't speak about the directive too much because Ben already did it. But so first strategy, I think that the experience of the first European Assembly of Careers is very interesting because it was a question of building collective local actor. It means to see how they act locally and how it was possible to think globally and maybe one day to act also globally. But it begins at the local level when new collectives are being built by couriers or drivers thanks to social networks. And I think it's important as point of method to think about the new tools of communication between the activists and also about the protection of their data. And I think it's also a big point in the directive now, and I think that James will speak about it afterwards. But after having aggregated into a collective riders and drivers, they mobilize at local levels but with or without the unions. And here it's also a big point because the difficulty in the different countries is to link these autonomous workers collectives and trade unions, in France particularly, but in other countries. And so I think it's it's a big challenge to continue to do it, to see these different links with unions and autonomous collectives. So in the map here, you will see all the collectives and the unions that in the European General Assembly. And you have to say that before, the 2 years before, they organized 40 mobilization in 2017 in 15 countries. So it was a big wave of mobilization at this time. And but even if there were a lot of strikes, they couldn't get really like you mentioned now with the new strike in France. Even if there were lots of organized direct actions, it was very difficult to get the concrete demands. So, and I think it's a big point to see that one of the strike who get a really big result, it was in the UK. In UK, I think James remember about it, when collectives have developed new alliance with a broader front of precarious workers of McDonald's in the UK in the summer of 2016. It was a big the win at this time, and I think it's a very important point to say that to continue to develop this new alliance with other precarious workers, Uberized and people from the McDo or also undocumented people. They did it also in France recently. So all these struggles, however, rarely lead to concrete collective bargaining. And even if maybe you will mention it in Italy, I think when you got a lot of agreements, but mostly it's very difficult. So faced with this limit of local struggles, we see the need for an international alliances and we try to do it with this European General Assembly. There were 60 collectives and unions from 12 countries. You can see it on the map. And then you have the UK here, France, Germany, and Italy in the photo. So all these collectives and struggles in the different countries push to create a network called, and you see the logo here, Transnational Federation of Careers. So at this moment, at this period, with big struggles, it was very important, this network, and it was called, Transnational Federation of Couriers. But now it's more and more difficult to maintain the link between all these workers. The actual name of this network is Precarious Riders, and it continues. But 2 years later, in October 2020, was born an international coordination of platform, Alianza Unidos World Action. You see it here, bringing together mostly not only riders, not only couriers, but also drivers. And it was an interesting also network, the result of two factors. First, because there was a lot of local mobilization also in Latin America, very much, and also because of the pandemic in March 2020, as you mentioned at the beginning. So this gives birth to 5 international strikes, this Alianza Unidos World Action. But so I think this international, transnational networks are very important to continue to build it, because it's like to create a common identity in the face of this multinational platform, and to create like a new internationalism, even if it's very difficult. Concerning the demands of these networks, we had, for the first one at European level, two main demands. It was data transparency, and we see how it's important now in the directive. And second one, the minimum hourly wage. Yes, and it's the same. It's also very now in the directive we get it. We don't get it, but it was also the demand that you mentioned in the strike in France. At international level, with Alianza Unidos World Action, you had big demands. First, defend social rights, and second, and at this period, it was not so normal to speak about the creation of digital rights. Now it's really a big point in the directive also, and I can imagine that James will speak about it. Yes, you see here the demands of Alianza Unidos, but what is very important, it's already in 2021, they ask for fight for your rights, we are employees. It means then that in Latin America, they were aware of the importance of the presumption of employment that we already tried to get in Europe. But there they don't have it in the American continent. So that's why it's so important to continue to struggle for it in Europe. That's the point of the second strategy of legal action. So what we see when I speak about the status war, it's because one of the essential point of the strategy against naked work is, in fact, acting on the law. I distinguish here between the case law and the legislative aspect. So, and I won't speak a lot about European directive, you did it. So first, the case law, the national case law. Why it's important is because the indicator you mentioned before, Ben, are coming from this national case law. And so it's very important to see if really they choose some of them, and if they will be easy, it will be easy to control them for the platforms. So many workers across Europe have had their status reclassified until now as employee by the courts. And what is important is that it's all highest instance courts in France, in Spain, in Germany, they get it. In Italy and UK, it's a little different because it's more like third status, with the status of worker in UK and hetero organizzato in Italy. But so we see that the case law is increasingly favorable to reclassification and so to the right of platform workers. The problem with the new directive, you mentioned it, Ben, is that this criteria, these indicators, they will maybe stop this possibility of reclassification. And so it's worse. It's worse than before if it is like that. Then, so what we see is that the consolidation of case law only what is only in Spain and in Belgium, when we already have law about platform workers. But what we see is that it doesn't work. It's not applicated, in fact. So what are the national states doing at the end of the day? And what can we attend for this result of the directive? Because I think we don't have to think that is a victory, because it's more the application afterwards with the different states that will be very difficult. Most European states support platforms, and we see it particularly in France, but also in fast, well, without Spain, there are really fast all supporting platforms. So the business model of Uber extends their own policies of deregulation of labor law. It's a good mean to do it again. So the political victories, we just have it in California, you remember, with the law AB5, in Spain with the law rider. But what we saw afterwards, we saw that this law AB5, it cancelled with the proposal 22, and in the US. And in Spain, what we had the law has been bypassed by the platform. So even if you have law, when law is adopted, the platform don't care. So that's big. We really have to have it in mind for the implementation of the directive. So that's why I think the follow-up of the different laws in progress, but also the future implementation of the directive in the countries is very important in the political fight to come, and in the unions fight to come also, because we can imagine that there will be also division between unions, unions that will maybe make agreement with Uber, and others that don't want to make agreements. And I think it's a big step in the unionism in Europe to see how it can change also the political future of the different unions. So as I think, yeah, what's up in the EU, I want to speak too much. So I don't speak just a question about the platform work directive, because you already speak about it. For me, since the beginning, since 2019, this directive is dangerous. But because the idea from the directive is to get a minimum social floor to platform workers. But what does it mean? We can really ask the fundamental question: is the aim of the directive really to improve the labor condition of platform workers? Well, that's a pretext, huh? Or to, at the end of the day, regress the labor condition of all workers with a new minimum social floor, which will drive all the employee contracts in all sectors towards this minimum. I mean, it's a question to ask, because even if we seem to have a good text, I think that this general question continued to be very important. And that's why all workers are concerned with the future of the European Directive for platform workers, not only drivers and riders. So, yes, about the text, the last text of last night, just reflection because of what you said before, Ben. I think the big stuff is about the possibility at national level to add criteria. It means that each country can do whatever it wants with the reclassification process. It's a big problem. It's a very big problem. So I don't see a real big victory. Maybe in the part concerning the algorithm, but I let James speak about it. Maybe it could be better, but I don't know. Well, just last conclusion. I don't speak about it. Challenges and future prospects about the trade union representation and new digital rights. I think that's very important to that unions, as I mentioned before, get new strategies to organize, mobilize, and represent effectively platform workers, and not just make agreements, but really try to represent themselves. And it means it includes also undocumented workers. And so I think that the process of houses of couriers are very interesting as space for collective action. There is some types of houses like that in Vienna, in Brussels, in Paris, in Lisbon. It's new space, like new space for new unionism also. I think it's an interesting thing. And maybe also important to try to see how to fight against partnership unionism, against yellow unionism all over Europe. And then other important challenge, extension of the struggle, convergence with other workers, with undocumented workers, with all the workers in the precariousness, and also employees, because they are directly concerned, as I mentioned before. And then I let the question of the new digital labor rights to James, because I think he's better in it than me. But yes, I think we really have to see what's up in the directive about it. Last points about the collective action and legal action. I think that there are really complementary strategies. And since 2019, it's more and more difficult because collective action has been really declined. As the population is in a state of survival, it's more and more couriers and couriers in a state of survival, and so difficult to mobilize. That's why I really think that in terms of strategic perspectives, it's really the accumulation of forces in the struggle and the construction of collective players that will open up the possibility of a victory for workers in this ongoing battle over status. And this battle is not at the end, because it will be that we will have 2 years of implementation of this directive. Yes, so, well, the struggle continues.
Thank you, Anne. I should have said at the start that after each presentation, if there's any direct questions for the speaker, you are welcome to ask them. At the end of the presentations, we will have plenty of time for a general discussion. But just to see if there's anyone who wants to ask a direct question to Anne right now before we move on to the next presentation, then please go ahead. No, okay. We will move on to the presentation of James Farrar. James is the head of Worker Info Exchange, a platform worker data rights campaign organisation in the UK. He's a former General Secretary of the App Drivers and Couriers Union in the UK and a former Uber driver. He's led some of the most important legal actions in Europe for platform workers' rights, including one which is currently ongoing in the Netherlands, and I'm sure he will explain about that, and which could have big repercussions for gig workers' data rights across Europe. So James, go ahead.
Thank you, Ben. Can you hear me?
Yes.
Yeah, I can hear me. Okay, thank you. Well, thank you, Anne, for your presentation. Thank you to the colleagues in Slovenia. I reckon Slovenia must be the most beautiful country in all of Europe. So it's a pleasure to join you. It's a fantastic, the most natural paradise I think I've ever been to. So congratulations on your beautiful country. You know, just to reflect on the Platform Work Directive a little bit. Sorry, I'm just, yeah, there we go. I wanted to tell a little bit of a personal story about why data became so important to me personally, and the inspiration for carrying on to form Worker Info Exchange is a personal story that comes out of the, you know, as part of the worker rights claim against Uber in the United Kingdom. And when I went to tribunal, Uber came with all of my personal data to use against me. And one of their big arguments about why I was not a worker and why I was not entitled to minimum wage was because I had a relatively high cancellation rate. And now I spent 7 years working for SAP, the German software provider, before I went to the other side of the chasm, of the technology chasm, and was working for Uber. And so what my understanding of an on-demand system was that what it doesn't really matter whether I accept the job or not. It's an instant on-demand service. So if I accept the job or not, it's not going to be any great problem for the consumer. So I had a high cancellation rate, and you know, at that time the jobs would come thick and fast, and you had 5-10 seconds to accept it or not, and either way it's being used against you. And so I was probably doing about half the work that I was offered. And Uber tried to make the argument that since I had this control to refuse work, why should they give me the minimum wage? Because all that would incentivize me to do is to sit at home, watch television, and continuously cancel jobs while I'm getting paid minimum wage being logged in the app, which is clearly an absurd situation and was untruthful. But what I looked at the data a bit more carefully, and I looked at the data they provided, and I looked at some of the onboarding documents, the training documents that Uber was publishing at the time. It turned out that although I was refusing half the work that was offered to me, my actual production rate was higher. So Uber published in an onboarding document, they expect you doing 3 jobs an hour for a 40 to 60 hour week is kind of the production they expected. And at that level, you would earn X and Y. But it turns out I was doing more than that on a 91-hour week that was used as the example in the tribunal. So I was more productive at 91 hours for Uber than they actually published in their expectations for a worker working 40 to 60 hours. And yet they were making the argument in court I didn't deserve minimum wage for that, and actually went on and used that date and that example in parliamentary hearings in before Parliament in Britain. And so it just made me feel like, you know, we as workers have to have better control over our data. We're going to lose every single argument. And the thing that's changed since then is that in a way that the case we were able to mount against Uber starting in 2015, we wouldn't be able to do it today because a lot of the evidence that we relied upon is now concealed. They don't say the things that they used to say. They don't publish the things they used to publish. And the absurd thing about, which I want to reflect upon a bit in the Platform Work Directive, the absurd thing, although there is this notional reversal of the burden of proof, all that really means, as I understand it, is that when you go to court to assert your rights as workers, you'll get the benefit of the doubt before the judge, but you still have to go to court to make the argument. So it's not as if you have, you know, the presumption of employment from day one in employment. No, you will still have to go to court, and you'll enjoy the presumption in court. But after you've taken that step, which is never an easy one for precarious workers to do. But the reality of this type of relationship, somebody once said to me, no, employment is like a relationship like any other. And you imagine the absurd situation where you say, you know, like, Ben, you and I are in a relationship together. And Ben says, no, we're not in a relationship. And I say, oh, no, we are. And that's essentially what's happening between Uber and Deliveroo and their workers. They're, you know, the workers are trying to say, we're in a relationship here. And the platforms are saying, no, there's no relationship here. And the burden is upon us to prove that we're in this relationship. And so the reason now why algorithmic transparency is so important is that a lot of the management control is now concealed in algorithm. It's never going to be said, it's never going to be published. But you better understand how the algorithm is working, because the algorithm is controlling you, and that's how management control is expressed. And management control, in a way, at the end of the day, is what defines an employment relationship. So it's really important to get that transparency. The other thing I wanted to just say about this presumption of employment, the very fact that we've had to have this argument in Europe, in a way, it shows how the platforms have won. Because in the 2015 ruling we had that was upheld by the UK Supreme Court, the judge in his ruling said the idea that there are 30,000, at that time is about 100,000 now, there's 30,000 Uber drivers, that they're self-employed entrepreneurs making up this mosaic of Uber in London. The judge said that that was faintly ridiculous. And yet, here we are in Europe. We've got these the council and the trilogue, and the council and the parliamentarians and the commission, you know, bending over backwards amongst themselves to try and define whether or not this guy and this girl on a bike delivering food, whether or not that they are a booking entrepreneur or whether they're a worker. Of course they're a worker. They always were workers. That's just common sense. But yet somehow these workers, the most precarious, the most in need of employment protection, are the ones that have been held to this highest standard of proof that they are indeed workers. I mean, the very fact that that argument has had to be had is just manifestly unjust. That's really all I can kind of say about that presumption. So I just want to move this aside. Yeah. So So in terms of what we're trying to do in terms of algorithmic management, then is to plumb for that transparency, particularly in pay, how pay is set. In many jurisdictions, this is defined in regulation. It's very important that your contract tells you what your hours of work will be, what you'll be paid exactly. And yet these platforms are increasingly opaque about how work is allocated and how much you're actually earning. And then performance management, including dismissals. How are you performance managed? Are you, who gets good work, who gets the better work, who doesn't, and how people are dismissed. And then a key in all of that is automated decision making, because automated decision making under data protection law attracts additional protections. So we set about setting up a data trust, and I don't want to get into a long debate about, there's a torturous academic debates about what a data trust is and how it's to be governed. We have a fairly simple idea of that. We're just simply trying to work with workers to aggregate their data, so that because we think that that can be a powerful force for organizing, because everybody wants to know how this app, how this technology is managing them, how are they doing relative to everybody else. Because there is a lot of rumor, there's a lot of misunderstanding, there's a lot of shame and guilt as well. I know when we first started organizing, I started saying I'm not earning minimum wage. People would kick back against you and say, well, you don't know what you're doing, you don't know how to do this job, that's why you're not earning enough. But gradually people started to come around and understand, and accept that none of us were making money, no matter how much we tried to persuade ourselves and others that we were, or that we would eventually. So I think data aggregation is fundamentally a very important force in organizing and for getting a collective understanding of what the true conditions in the market are. And our objectives as a trust to understand that pay per hour on aggregate, what the utilization is like, you know, because there's an inverse relationship. The more excess supply of labor and vehicles there are for the platform, the greater their network effects are, the greater their competitiveness is, because they compete on a fast response time. But that fast response time is made possible by an excess supply of labor, and that excess supply of labor means underutilization and lower yields. So our economic interests are diametrically opposed. And frankly, until workers are paid for all of their time, all of their waiting time, as well as their delivery or driving time, the gig economy problem is unlikely to ever be solved. That working time problem is not addressed in the platform directive. And it hasn't properly been addressed in the legal challenges around Europe that I've seen so far. And yes, of course, a challenging unfair automated decision, whether it's the docking of pay or dismissals due to facial recognition systems failures, we've challenged successfully. But all of those decisions, nearly every decision that's made by the platform, will be automated, because these companies are hollowed out inside. They don't want to have a lot of HR staff. They don't want to have a lot of driver support staff. They want to automate almost everything. And that's, you know, that's a bit of a Kafkaesque nightmare on the one hand, but on the other hand, it's an opportunity for us, because we must challenge that, because black box decisions over people are challengeable and should be challenged. So how we do this, we set up on our website, you can see that we've got you sign a contract with us through an automated system called Scrive. That gives us the right under GDPR to, well, you delegate the right to us to make the request on your behalf to the platform. And that's usually preferable, because otherwise the platforms dodge and dive and do not properly service the request. That's been our experience for a long time. We certify your identification by use of Onfido. So Onfido check your ID and then issue a certificate that says you've been identified, and then destroys, you know, so if you've given driver license details, we don't retain that. Onfido checks it, issues a certificate, and then the data is deleted. And that's acceptable to the platforms. And we've been successful. I mean, for many years, since 2016, we've been pushing with Uber, and eventually last year, they did actually agree with us a data transfer protocol. So we now have an agreement with Uber that we make one request. We make the request, they do one check with the driver rider, and then we receive the data. And this is a big step forward, because part of the obfuscation problem was they would insist that you can only make the data requests in-app. And that means everybody else is kept out. You don't control the correspondence trail, which is important for a regulator to see in the event of a dispute. But they would insist upon this, and then they would find ways of delaying, because every time they ask you a question, when you ask for the data, then the clock stops. So they can ask you an obtuse or weird question. There's lots of little tricks of how they can stop the clock for the 30-day response time. But I'm pleased to say we've sort of overcome all those games with Uber, and we have an agreement with them at least. This is not to say that we feel that we get a full disclosure of everything we're entitled to, including explanation as well as access to the raw data itself. But at least we have the protocol, and we have a taxonomy of the data that they committed to, at least in 2019. They've tried to back away from it since, but we at least have a statement from them of the data and a description of the data and the data fields. And we also have an agreement for them to provide the data. The rest of the platforms pretty much useless. But what we now need to do together, hopefully, is to pressure the other platforms and the regulatory authorities to say, well, look, if even Uber can cooperate at this level and provide this level of data, there's no excuse why the other platforms are not doing the same thing. Right. And the final thing I would say about the value, besides the aggregation and understanding market conditions and challenging unfair automated decisions, including dismissals, is never underestimate the power of an unforced error. You'd be surprised at the things that these platforms tell you, even by mistake. So one nugget that we got from Just Eat, we did an access request, and we demanded an algorithmic explanation of what we said was an automated dismissal of a worker. And they came back and said, oh, it wasn't automated. The reason why we dismissed this worker is that the bank account details they gave us for which the worker is paid into was the same bank account used by 49 other workers working for Just Eat. Now, that's a stunning admission for Just Eat to make. And Just Eat went on to say that they fired all of them, all 50 of them. Well, the idea of vulnerable workers sharing bank accounts is a leading indicator of modern slavery conditions, because you have to ask yourself, well, who is now controlling that bank account? But it's an example of the kind of things that you can get by surprise through an access request. Something will flush out because they're giving you a lot of data, a lot of it's unstructured, and you never know what they're going to give you by mistake. The other hilarious example was with Vizu, a big regional operator in Britain. The data protection officer, the head of legal, received the request, and then he was emailing all his colleagues and telling them how important it was that they reviewed the data sent back to us to scrub it of any evidence of an employment relationship. But the only problem is that he by mistake put us on CC in that email, which is just absolutely hilarious. So this is a good opportunity to try and pierce the veil, the corporate veil, and you never know what you'll get in an unforced error when you do that. How am I doing on time, Ben? Am I okay?
Yeah, you're fine.
So I want to talk a little bit now about those are the reasons why you would assert your digital rights, but I want to talk a little bit about the limitations of that. There's poor and very slow regulatory enforcement of both data and employment law. Maybe it's true of all regulation, all law. But the data protection authorities around Europe are at times politicized, they're under-resourced, and they're very slow at generating any kind of a decision or a response. Same with employment law. Notoriously poorly enforced across Europe, and as Anne rightly said, the underpinning of employment law in Europe is a common European strategy for labour market flexibility. So underneath the policy assumption is favorability to the types of employment or lack thereof opportunities provided platforms, and there's a strategic lack of appetite for challenging the abuses. And so it's up to us to activate and agitate to make sure that they do, to tackle the abuses, because the politicians and the policy framework's not with us. Litigation then, on the other hand, is not a silver bullet. It's slow too, it's expensive, it's time bound. So even if you win, you know, what your opponent will say, well, they'll say this was a specific moment in time with a specific number of claimants, and it has no wider application. Of course it does, but the challenge you'll have at the end, even when you win, is making sure that it does have broader application. I'll come back to that in a minute. And even then, the win you get isn't always necessarily the win you think it is. And then when you win, and to go ahead and get remedy from that can be difficult as well. This is not to say you shouldn't do litigation. I'm just saying that all of these things, like when you go into the arms of the state, either through litigation or through regulation, it's slow and is resisted. There's a resistance in the system. So don't expect miracles. The other problem with data protection is that the underpinning of data protection law, the GDPR, is about individual rights rather than collective rights of workers. And this is why the Platform Work Directive is important, because it begins to, you know, for the first time, really look at digital and data protection rights through the eyes of a collective, which is really important. And that work needs to be developed further. And like I say, in terms of access, there's lots of opportunities for these platforms to stall you, to divert you. Some of the tricks include taking the so-called layered approach. So you've asked for your data, and then what you'll get is some kind of skim summary. If you don't know better, you might accept it. But then when you challenge it, they'll say, oh, well, we were taking a layered approach. And this is something that the European Data Protection Board said was okay to do, but it's a trick. So you have to be up to that trick, or you may not, you may not get what you're entitled to get. And then the portability, the right to port is limited also too. You may not be able to get all of your data ported, although you can get the right to access all your data. And then in terms of automated decision-making, what Article 22 talks about, there's this general prohibition on decisions that are solely automated. And that word solely is carrying a lot of weight there. What is a solely automated decision? What's a semi-automated decision? What is meaningful human intervention? These are some of the things that we challenged in the court case that we brought in Amsterdam that brings some greater understanding about this. But it'll be important in the Platform Work Directive as well. The platform, what Ben was describing as general prohibition on automated dismissals, robo-firings, which is what our litigation was about. But then what is not a robo-firing case? So if the system suggests that you should be fired, and the human is in the loop and says, agrees with the system, you should be fired, what is the nature of that human intervention? Do they understand the systems? And then when you ask for an explanation of what the system is doing in terms of algorithmic transparency, what is an acceptable explanation of what's really going on? These are things that are still not clear and will require a lot of regulatory decision, a lot of litigation to get greater clarity on it. So we have our work cut out. So we brought these cases before the courts in the Netherlands. We did so because the data is collected there and was going to be less expensive and less risky for us to take the litigation in the Netherlands. So that's what we did. We challenged in terms of access rights, but then also against specific unfair automated decisions. And so the court upheld, this is important, this idea of individualistic approach. So both the platforms, Ola and Uber, try to make an argument that it was an abuse of the access rights that a trust like Work Info Exchange should be in the loop here. They saw that that type of collective action is an abuse of the right of the individual. And the court took a moral position on that and said it's far from it being an abuse. It's actually the point. Article 7 of the European Charter is the basis of these rights. And what the court said was that the work of Worker Info Exchange and the work that all of you will do in the future strengthens the individual's control over their data. And that's really important thing to do. You want to empower people to control their privacy, to guard their privacy, to manage their privacy. And you need to build that capacity. And the courts made a really clear moral statement about that, to push back on these platforms and say, far from it being an abuse, is actually the point of these rights, if you root them back to the Charter. The courts also rejected arguments from the platforms that their trade secrets could be violated, or that their security could be compromised. This is not to say that we can have access to all the trade secrets and we can bypass their security. The point is that if you're going to make a decision to dismiss somebody, say, for alleged fraudulent activity, they have a right to know what the allegation is. It's really that simple. And it's almost like when you say these things out loud, you can hear the absurdity. I can say, Ben, you're fired. And Ben says, well, why am I fired, James? And I'd say, I can't tell you, it's a trade secret. Do you know what I mean? Like, if you say these things out loud to yourself, you can see the absurdity in it. But yet, these are the types of arguments that the platforms are trying to have and saying, we literally cannot tell you why we fired you. It's a trade secret or a security issue. No, if you're being fired, you need to know what the allegation is against you. You need to be able to have your point, say your piece about it. The court also ruled about tags and so-called fraud probability scores. So using fraud probability scores in a decision to allocate work. I mean, this is predictive analysis about predicting your behavior. It's unacceptable. And the court said that has to be made transparent now. But the likes of Ola have used so-called fraud probability scores. Free Now has talked about this as well, but when we challenged them on it, they immediately reissued their data protection policy overnight. So other internal performance data must be disclosed to you. So if the you know, in this step of conflict over transparency, you have the data that you fed into the machine yourself, and then you have the observing you at work data, your GPS data, the tracking data. And then you've got so-called inference data, and it's the inference data they really don't want to give you, which is like, what decisions are they making internally about you based on the data you've provided them and the data they've observed about you. And so things like fraud probability scores and other performance tags are really, really important. There's also, you need to combat abuse. Just a personal story from my side. I drove a passenger to Gatwick Airport, and you have to pick up the passenger in the car park. So I went into the car park. Now I have to pay £3 for parking. Then the passenger cancels. So now I have to leave the car park. I've paid £3, but I've no fare to collect against. So I wrote to Uber, and Uber said, oh yeah, no problem. We'll refund that to you. But later, when I did a subject access request, I saw in the logs that a customer service agent for that incident applied a tag to my profile of inappropriate behavior. And what she wrote in there, she was new in the job. She wrote, I attached that tag because I didn't know what other tag to apply. And I guess she's a part of her job. She has to apply some sort of tag. And so what we were trying to get to the bottom of is, well, how are those tags being processed? Are those tags being processed in work allocation? But unless you have this kind of transparency, yeah, people can attach all sorts of nonsense tags to your profile, and you've no way of challenging it or correcting it, even if you don't have transparency to it. And yes, the courts recognised there was evidence of performance management in the data, and how important it would be for us to have access to that. In terms of automated decision making, the courts found that there had been an automated decision to dock wages. We think it's the first ruling of its kind in Europe. This was at Ola. It was part of a fixed price fare that the passenger then decided to go to another destination. The fare increased as a result, but the wages were automatically docked. So in other words, a driver was asked to maybe go 5 miles for a fixed price, but then the passenger changes the destination. Now they go 10 miles, but they still only got paid for 5 miles. They were billed for 10 miles, but then the system deducted it back down to a 5-mile journey. It couldn't get it corrected. There was no way to access a human to get that understanding that needed to be changed, and so it was ruled as a machine decision to dock wages. There was confirmation that workers were dismissed without meaningful human intervention. This is about workers who were accused of fraudulent activity, and Uber had argued that these decisions were reviewed at a service center in Poland, but the courts, what their opinion on that level of human review was that they said it was nothing more than a symbolic act. That the people reviewing these decisions had no real basis for reviewing it. They had no knowledge base. They never talked to the worker, and so this gives an insight into what is or is not acceptable human intervention. And this is an area that will, there'll be lots of challenges on in the future to get a greater definition, and it's up to us to demand greater definition around this. And there was critically there was an order for transparency around dynamic pay and dynamic pricing systems. I think the issue of dynamic pay is going to be a huge issue into the future, for various reasons. But there's an order for transparency. But again, what is an acceptable explanation? We're going to get a bland explanation. I mean, what the GDPR says, we need to have meaningful information that tells you about what the envisaged consequences of this type of algorithmic decision making might be. I don't think we're anywhere close to meeting that standard yet, but that's a fight we'll have to have. Now, Uber was ordered to provide transparency in April. In May, they provided some transparency. We said that the explanations that they gave were not acceptable. They didn't meet this standard of meaningful information, and an understanding of the envisaged consequences. So we had a sort of standoff for 6 months, and Uber eventually went to court to get a declaration that they had complied, and they lost. The court agreed with us that Uber hadn't complied. So we're still negotiating with Uber. They went off and commissioned Deloitte to to do an audit of these systems and to give us a greater algorithmic explanation. I'll be honest, I don't think they can ever give us an explanation I'll be happy with, because it'll never be 100% transparent. But we've made some greater progress. But they owe a lot of money and they haven't paid it up. But that's over 800,000 now. Yesterday, 820,000, due to 3 workers to share. So that we're not finished yet. But I mean, in terms of all of this, what I worry about both the GDPR and also the Platform Work Directive is that I'm not sure it's really fully incorporated a proper understanding of the AI machine learning environment we're now in. With these dynamic pay systems, I mean, real-time variable, hyper variable pay systems, to get an explanation of how pay was set today and to get that in 3 years' time, that's not practical or reasonable. And yet I don't know what the correct regulatory solution to that is yet, but I'm pretty sure the Platform Work Directive or the GDPR is not getting us to where we need to be to keep pace with this level of technology proliferation. And in terms of automated decision-making, work allocation, I mean, this transparency that's required, under existing law, it's just not happening. Like in Britain, we have the Section 1 statement in the Employment Right Act. You have the right to know on day one what you're going to be paid, what the conditions of that pay are. So your hours and your pay. There's no way a worker logging in this morning to work for Uber or Deliveroo has any clue how much work they're going to get, and if they get that work, how much they'll be paid for it. We're nowhere near meeting that standard. In terms of consent, also, this is an issue, I think, in the Platform Work Directive. It'd be interesting to see how it plays out. Workers simply can't give consent properly. So you may sign contracts with your employer, but the courts have always recognized, almost like this presumption of employment status, the court have always given a presumption that you couldn't really give proper consent because you don't have bargaining power with an employer. So, with the contracts that I signed and others signed back 2014, 2015 with Uber, the parliamentary inquiry called those contracts gibberish. I mean, they were just complete nonsense of what you're consenting to, what you're agreeing to when you click I agree. But it's always been recognized that you can't really properly give consent. And the same thing with data protection, except that consent is a factor in the GDPR. You can give consent, but that's because as an individual, whether you're a consumer, the playing field is a bit more level than it would be if you're an employee. So there was some sliding in the Platform Work Directive to maybe fall back on consent as a principle, and the truth is workers cannot give proper consent. And what we could see then through the Platform Work Directive, if this principle got hold, is an undermining of this principle about consent from employment law. Latent control, this is an important issue. So if waiting time is not working time, but the algorithm is keeping me on the street, say, longer than Ben, because they rate Ben better than me. So Ben gets more work more quickly and I get less work less frequently, then I'm controlled. My waiting time is controlled. And if that control is being exercised, surely that's working time. So we need to understand how work is allocated, who's getting work and who's being detained. Okay.
James, can you start moving towards wrapping up?
I'm finished. Well, I'll share I'll end it there. I'm sorry to drone on too long, Ben. But I mean, if Ben wants to share these slides, I've left some notes with some references on the back here. The Platform Work Directive, our report managed by bots, kind of details all the troubles and problems we've had in accessing data with various platforms. There's a link here for a press release and the rulings that we had in Amsterdam, so you can read more about those cases. Our report on robo-firing at Just Eat, our recommendations last year, well outdated now, on the Platform Work Directive and the Supreme Court ruling, and then as well as the EDPB guidelines on the rights of access for data subjects. Thank you very much. I'm happy to take any questions. I hope that was helpful. It's a lot of information. Thanks for your time and space, and it's an honor to be here. Thank you.
Thanks, James. I don't know if you want to just say something briefly about the help you're looking for.
Yeah.
Yeah, do you want to just mention that briefly?
I do, and thanks for reminding me, Ben. So what we're trying to do now is, because we've had this ruling in Amsterdam, what we're trying to do is, okay, so litigation is good for proving a point. Right, you know, if you can stimulate a regulatory response, it's very hard to do because they don't want to and they don't have the resources. But on the other hand, if you get a regulator to move, it can have a huge impact. So what we're trying to do is to amplify the ruling in Amsterdam by ramping up the pressure on regulatory authorities of Europe and sort of saying, you know, look, what the case in Amsterdam showed and what behavior since shows is that all of these platforms are systemically failing to honor data subject access rights for all workers across Europe. And so what we're trying to do is work with local groups and local countries. All you have to do is to have a few workers make some subject access requests. And then when you don't get the proper response, we will file with you. You'll file a local complaint with your local data protection authority in Slovenia, Austria, wherever. And then we work together, because the idea is that, like, say, Uber's data is controlled in the Netherlands. So if a complaint is made in Slovenia, the Slovenian data protection authority is responsible to the data subjects in Slovenia, but they also have to refer the complaint to the Netherlands, to the data protection authority there as the lead supervisory authority. And then you've got the EDPB above all those authorities in Europe. So what we want to do is apply this peer pressure. We can say, okay, Slovenia, you have a complaint now, but you should be aware that the same complaints will be made in France, the United Kingdom, Sweden, Spain, and elsewhere. So, you know, you can't really hide and put this on the back burner, because there are coordinated complaints across Europe. And what we want to do is drive these together. If you want to join in with that with us, what we can do is we can provide you with the template of the complaint to make, and that complaint is being put together by our lawyers. And you just tailor it to local need, but it draws on our research that we've done of other rulings, our experience, and the behavior of the platforms, so that all you have to do is to add on top of that there's been a failure to comply in Slovenia, and here are all the legal arguments about why there needs to be a response in Slovenia, and by the way, it's coordinated across Europe. So if you would join this, it's a kind of a campaign to push the regulatory authorities across Europe to start acting, start coordinating together. It'd be great to have your collaboration to do that. It's a very simple thing to do. And then you can put out a press release saying that you've joined this initiative and that you're pushing the Slovenian Data Protection Authority to act, and that they do so in coordination with their colleagues across Europe.
Thanks, James. I'm going to bring in Marco, who has a question.
Thank you, James, for this very interesting presentation. I'm a trade unionist from Slovenia, working as an organizer and representative in the British NHS. Therefore,
okay.
Yeah. So therefore, automated decision-making is something I don't come across as I deal with HR day in, day out. And it's quite shocking to see how dystopian and opaque this system is in the gig economy. My question would be, do you see any opportunities to weaponize this automated system and its failures against the platforms? You said that they refuse to pay fines or comply, so that is a bit worrying. Obviously, you know, legal options are a tool, as you said, but they don't necessarily always lead to permanent solutions. Well,
I mean, the initiative that I just described is our thoughts about how you weaponize it. But look at it more negatively. I mean, I think it's healthy to be cynical. But I would argue it's almost the other way. It's a sport, because either way we win. Because if we go to court, we go to the regulatory authority, and we lose, we can say, well, look, see, the law doesn't work. The law cannot provide the proper protections for very vulnerable people. We need reform. If we win, we can say, well, you see, we've won, and that just goes to show that the law hasn't been properly enforced, and we need regulatory authorities to act. So it's how we conceive, you know, the meaning of of the action or inaction of the regulators is how we weaponize it. But what's really important in all of these things is that there isn't a silver bullet. You do need to litigate, you do need to regulate, but you do need to agitate as workers as well. And probably the third one is the most important, because when workers are organized, when they put the pressure on politically, and they put economic pressure on their bosses, that's when things start to, you raise the temperature. That's when it starts getting really uncomfortable for everybody, for the employer and for the regulator and for politicians. That's how you drive change, but you got to do all three.
Okay, thank you, James. I'm going to bring in Murillo now. Murillo Peroni is a researcher at the Inca project at the University of Bologna on platform work and a member of the Into the Black Box collective. He was previously a rider and founding member of the Rider Union Bologna, which is one of the most sort of significant worker collectives in Italy. Murillo, off you go.
Yeah. Thank you, Ben. Just one moment, I show my screen. Okay, so just... Okay. Can you see it? Okay, perfect. So I will give you some insights about a specific case, the Italian food delivery struggles. I will try to give you a picture, a very quick picture of the actors, the goals, and the practices that have been implemented during last, I would say, 6 years, 7 years, around the definition of the food delivery sector in Italy. I'm referring especially to this sector first as I have been engaged, as Ben said, in the struggles, and I worked as a rider too, so it's the thing I know better than the others. And on the other side, as the food delivery sector has been a sort of symbolic sector for the struggles of platform workers, but more generally for the reorganization of workers' rights in Italy during last years. So here I sum up some features, of the platforms and unions in food delivery sector in Italy. And on the side of the food delivery, we may say that companies expanded from the north of the country to the center-south. So for this reason, we witnessed the first forms of organization, especially in the center-north, in the north of the country, and then to the rest of Italy. And another feature of the Italian sector was that it moved from the big cities of the north, so Turin, Bologna, Milan, to the rest of the big cities like Rome, Naples, and so on, and then to towns. So more or less, this expansion embedded all the Italian territory. And then third element, we have international players like Uber Eats, Deliveroo, Glovo, Just Eat, and so on, and local experiences. So we witnessed the attempt to build up some local players that step by step tried to reach a national dimension of operation. So these two local experiences of Sniam that was active in Bologna and My Menu that was active in other cities of the north of Italy, then they merged and then created an Italian player that just in these days has been sold to Glovo. This to give you an idea of the concentration of the market in Italy, and I will explain more about this later. On the side of the workers, we had a shift from informal and urban unions that were the forms that workers adopted initially to organize, to more traditional and national unions. This shift led also in a change in the forms of action and organization. So if at the beginning we had these informal, self-managed, worker-centered, conflict-centered unions, we moved more to forms of social dialogue, not exactly in the same way of France, but think that nowadays traditional unions are replaced informal unions, and their action is more centered in negotiation, dialogue with companies, more than on strikes, blockades, campaigns. Last point. It's important to remark how in Italy initially all the workers were hired as self-employed. Step by step, we succeed in shifting to an employee condition in some companies, and I will explain this more. And nowadays we have a polarized market with some companies based on a self-employment model, some other companies based on an employee model. So I will divide the evolution of the Italian mobilizations into 4 phases. This is the first. We can date it from 2016 to 2018. It's a period when there is, further we can trace back the first attempts to organize workers, and so in this period we have mainly informal unions in main large Italian cities in the north, and local mobilizations. So here you have on the left a chart, the timetable of the foundation of the main forms of self-organized unionism in Italy. So we have a first Deliverance in Turin in 2016, then Riders Union Bologna 2017, and then Deliverance Milano 2017, the same year. These 3 cities were the reference points for the first phase of mobilizations. In this period, we have a lot of local strikes, local demo that lead into 2008. So after 1 year and a half, 2 years, to 2 outputs, I would say. On first side, we have the legal trial filed by Turin riders against Foodora in order to recognize themselves as employee. This trial has been the first and a very debated trial in the public opinion, Italian public opinion, that ended with the acknowledgement that these riders were in Italy. We have not only self-employment and employment working condition, we have also something called hetero-organization, independent and partially subordinate to the organization, the vertical organization of a company. Anyway, to these workers are recognized the same rights as employee workers. So in this case, to these riders, the court recognized the same rights as dependent workers. On the other side, in Bologna, Riders Union signed this territorial agreement. Is a sort of local agreement. It's a sort of a secondary agreement, not a national agreement. It's a local agreement between Riders Union Bologna, so an informal and self-managed union, traditional unions, the municipality of Bologna, and 2 then 3 companies. So Sniam and My Menu, so the local food delivery experiences, and then Domino's Pizza, so 1 more international partners. The other big player like Deliveroo, like Glovo, and so on, they refused to stay in this agreement, assuming that just a national legislation could fix the problem, they said. So this charter was binding for the organization who signed the chart, and was based on the idea that workers needed a hour payment. So the charter fixed this hour payment referring to the national contract of logistics. The charter, moreover, assumed that riders need a fixed minimum amount of hours each month in order to avoid the risk of riders without enough working time. And third, the charter forced the companies to furnish workers with health insurance. We have to keep in mind that at that period there were no health coverage to workers, and that there were these system of reservation of the shifts. So riders had to rush up in some hours to book shifts, otherwise they to not have working time. In the second phase, then we have this period of 2018-2021 when we shifted to a national bargaining process. So in this case, we have more actors engaged in the debate. So not only the informal unions that step by step expanded also to other cities in Italy, like Florence, like Naples, and so on, but there is we witness the interest of many Italian traditional unions like CGL, CIS, and WIL to take a role into this process, while until 2018 they were quite aside, looking to what was happening, and for a certain degree also skeptical about the importance of the riders' struggles. Together with unions, we had also 2 ministers of labor, Luigi Di Maio and then Nunzia Catalfo, who were engaged in this national process of definition of a legal framework for food delivery riders. And then the companies that founded a trade association called Asso Delivery that saw the participation of more or less all the food delivery companies in Italy, from the large international players like Deliveroo to local experiences like My Menu. So what happened? We had different meetings. First, we had different meetings with the Minister of Labor, trying to define a solution, a national contract, a collective agreement, a law, And finally, as a collective solution, a shared solution was not possible to be defined, the Minister of Labor decided, the Minister of Nunzia Catalfo, Minister of Labor, decided to pass a law, the 128 of 2019, that was based more or less on the same principle of the Foodora trial, so that riders were addressed with the same rights as employee. Anyway, in this law, there were a potential clause of exception. So the law assumed that if a national contract would be signed between trade associations and representative unions, so companies could avoid to fully recognize the rights guaranteed by the law of 2019. So what happened? That Asso Delivery, the trade association, defined an agreement, a national contract with this right-wing union, UGL, that was not at the bargaining meetings before. And this contract, signed in September 2020, affirm that riders are self-employed and that they have to be paid by piece working. So this triggered a third phase of mobilization, concentrated in 2021 mainly, when we witnessed a market polarization. So what happens? The informal unions that more or less were separated, coordinated, but worked separated in direction, decided to form a network called Riders per i diritti, Riders for Rights. This network was a coordination between all the informal unions and the local branches of traditional unions like CGL, CISL, and WIL. So during the time, especially in the suburbs, especially in small towns, CGL, CISL, and WIL gave legal support to riders who wanted to organize, but did not succeed to do this in a self-managed way. Anyway, these local branches of these traditional unions found more how to say, more shared practices and perspectives with the informal unions, and so they all together created this coordination, this network based on local local organizations. And at the same time, the central bureau of CGL, CISL, and WIL started to try to negotiate with some companies, and this created some tensions between the network of local organizations and the central bureau of the traditional unions. Anyway, to protest against the contract signed by Asso Delivery and the right-wing union UGL, riders organized the 26th March of 2021, the first national strike in more than 30 cities. It was a coordinated strike between all the members of Riders per i diritti network. At the same time, a criminal investigation on food delivery platform by Milan Kurt targeted all the main players of food delivery market in Italy for two reasons: the lack of safety requirements, so the companies were not compliant with the law requirements for safety, for worker safety, and then also because there were an investigation into the legal status of workers. So the Milan court established that the contract of self-employment were not fully respecting the rights of workers in the food delivery sector. Third event, Just Eat, that in the meanwhile became Just Eat Take Uber group, decided to quit ASSO Delivery Trade Association and to shift to employee-based organization of its system of deliveries. So during the 2021, both the Rider per i Diritti Network and the CGL Chisholm Wheel negotiated with Just Eat the implementation of the logistic contract into Just Eat. So at the end, they signed a second level agreement that then has been adopted by My Menu too. So finally, we had this polarization of the market. On one side, some companies like Just Eat and My Menu hiring riders as workers, as employee. On the other side, Uber Eats, Glovo, Deliveroo, still addressing riders as self-employed. So this created the polarization, also because nor the first nor the second solution were totally satisfying for workers. In the case of Deliveroo, in case of the self-employment conditions, riders complained for the reducing fees of the shifts, for the lack of shifts, and so on. While in the case of Just Eat, many workers complained for the lack of working hours, for example, because company decided to do part-time contracts of 10 or 15 or 20 hours, while some workers needed a full-time contract. And they did this in order to then adopt the working time to the fluxes of to the demand of shifts, and so giving extra time, but in a casual and random way to workers, complaining for the lack of enough working time, and so for the low level of income. And finally, we arrived to nowadays the fourth phase. I would say that this phase was characterized by the waiting for the directive. So let's see what will happen from today on, as now this directive will have to be implemented at national level. So we will see if this will shake a bit the situation about what happened in these last 2 years. So protest leveled to a very low level of action. Informal unions disengaged or had to dismiss their activities because of different reasons, and I can spend more words on this if you want in the debate, while we have seen mainly traditional unions trying to lobbying on the European Union during the definition of the directive. At the same time, what happened is that we witnessed the market concentration in Italy, with some players leaving the market, like Uber Eats, but also like Getir and Gorillas, while some other, like Glovo, acquired some other players like My Menu. So more or less in this moment, we have 3 main players on the Italian market: Glovo, Just Eat, and Deliveroo. At the same time, the conflict did not totally disappear, while it assumed the form of casual strikes in many times organized spontaneously by migrant workers who are not satisfied with, for example, payment system, working time, and so on. But it lacks of a form of organization. So yeah, more or less, this is all from my side.
Thank you, Mario. Very, very interesting summary of the history of the sort of last 5 years of food delivery struggle in Italy. Okay, now I invite anyone who would like to ask a question, make a comment about Maurelio's speech, about generally what you've heard today. We have just over 10 minutes for discussion, so feel free to ask any question. Doesn't matter how, you know, small or big. Go ahead. Anne, I see Anne has a hand. Oh no, I've got 2 hands up here. So we'll start with Da. Want to go Da?
Okay. Thanks very much, Ravi, for that overview of Italy, which is yeah, country that has had interesting developments. And so my question is just kind of, if I just go straight to what you think, if you've had a chance, regarding the EU level and the sort of recent decision around the Platform Work Directive, and what implications you think it might have in the sort of foreseeable future.
Is that specifically for Maurelio, Da?
Yeah, yeah.
Sure. Okay, Maurelio, do you want to come back on that?
You want me to give a feedback? Okay, quickly. Honestly, it was difficult for Italian informal unions to stay on European level, you know, because they were accustomed to act on local level, while it was not easy to move on more transnational level. But I think that we have to frame this difficulty inside a more general difficulty of you know, the mobilizations, and we witnessed a decrease in the level of the protests last years, and I think also because we you know, we combined these to the shift from informal unionism, not only in Italy but also in other countries, to more you know, traditional unions. There has been attempts you know, to create networks, but my opinion is that these networks, it's something that I wanted to comment in the to the first speech. These networks had to deal with a scarce or very low level of activation. So it was more a form of networking for you know, communication, for share experiences, that than to coordinate actions. There have been actions of protests also in Brussels, also, you know, forms of debate with the European Commission, with some of the representatives of the European Commissions, in order to try to lobby the process, but we were not able to reply at European level the kind of a mobilization that we were able to do, for example, at national level. We did not have any, you know, European strike altogether in order, you know, to put pressure on this kind of process. Let's see if now we will witness a renewed activation at national level in front of the necessity to implement the directive in each single country.
Okay, I'm just going to take a question from the chat from Anwar for you, Maurelio. I've quickly put it into Google Translate because it's in French. So the question is, do you also have payment problems? Delivery workers complain about not being paid and end up being stranded because Uber refuses their bank card. So do food delivery couriers in Italy have these problems as well?
Yeah. Generally, these are the main reasons for the casual workers that that have been put in place in last year. Especially many workers complained because of the reduction in the payment. So the fares for the shifts were reduced more and more and more by the companies, especially the ones like Deliveroo and Glovo, who apply these contract based on self-employment. So workers complain a lot for the downgrading of the payment. And some of them experienced also problems, especially migrant workers, because, you know, these practice of account outsourcing that created a lot of problems also in terms of, you know, because we know that these are migrant workers, sometimes they needed this kind of work. On the other side, you know, this is creating a sort of hierarchy in workers, so not easy to manage this problem, and many of these workers had problems, you know, in the account disactivation.
Okay, thank you. Maya, do you want to ask your question?
Thank you. I would like to thank all three presenters. Your presentations were fantastic and very informative. Thank you very much. And I hope you will share slides, because James put some links there, which I would like to check. I have general questions for all three speakers, or four of you actually. Many trade unionists in Slovenia are very enthusiastic about this directive on platform work. I contrary share with you concerns about this directive and the impact of it. In the best case, it would have the same, it would be like with agency workers. It had, in the best case, no impact on their lives, working lives actually. So why why do we continue to speak about or guess about the impacts of this directive, but not fight against it and to take another steps? Then I see James' argument are right, that it's necessary to organize and to make pressure all the time. That it is very important, but it's also to search another ways of struggle against this situation. Then I would like to, if I may, just one. There is observatory on strikes of platform works worldwide. I think it's in Oxford University has this runs this and they found out that only less than 10%, I think, of strikes relates to the status of the workers. So very small little platform workers are interested in changing their legal status into employee, actually. How we should address this problem? This is interesting. Thank you very much.
Okay. I would like to come back on that last one, if that's all right, quickly. So I've seen the same study from the lead index of platform labour protests. In fact, I should just say we've officially got 4 minutes left, but I've been told we can run over a bit. So don't panic. I'm going to get all the questions in. Yeah, I've read the study and it's correct. So I think it was 15% of protests globally are about employment status. To me, that's not a big surprise, because platform workers are not so much interested in their status as they are in, you know, the things that can result from that, the pay, you know, insurance, all the practical things that platform workers have to deal with. That's what they're interested in. The vast majority of protests are about pay, and that shouldn't be a surprise. It doesn't necessarily mean they aren't interested in employment status, but generally, when workers organise protests, they organise around their most immediate demands, the things they can demand directly from the platforms. And obviously they can't demand employment status from the platforms, but they can demand higher pay and that sort of thing. Well, they can demand employment from the platforms, but they tend to focus on demanding, you know, improvements in their specific improvements in their working conditions. So I don't necessarily think it means that the other 80% of the protests are, you know, against employment status or whatever, or uninterested in it. I just think that the focus of protests tends to be on the specific demands that workers have. Having said that, it is true that a lot of platform workers aren't in favour of employment status. And there's still an argument to be won with lots of platform workers that it would be better for their terms and conditions. So without a doubt, there's a debate amongst platform workers about that. I think a lot of platform workers want to believe in the dream of flexibility and the dream of being their own boss and self-employed and that sort of thing, even though their experience in practice isn't actually that. Your first point, I think you're asking why don't we fight against the things in the directive which we don't like. I mean, there's been quite a big movement of especially led by the European Trade Union Confederation, the left group, the European Parliament, to sort of push for a sort of a general presumption of employment. So there has been some things that have been done about that. Maybe Anne would want to say more about the kind of protest movement around that. Anne, do you want to comment on that? And I know you have a question as well, Anne.
Yes, I think, yeah, for the directive, it's, as you mentioned, Maurizio, it was a shift also in the different phases. I think since 2020, most of the unions have been really involved in this directive process. And it was like if it was disconnected from the, as you mentioned, informal unions. Because they don't have the power to play at this institutional level. And so it's a big disconnection between workers that are less and less in capacity of mobilization because in survival, in undercommitted people and so on. And unions represented them, but without real links with the workers at this institutional level of EU, and with claims and demands that are not really the demands of the workers, I think. So I think it's like a big gap, and this gap between collective action and legal action at EU level is a big problem, because as you mentioned, there is no European strikes until now. So it's difficult. And the risk, I think, of this directive is to even if the text is not so bad, to regress the labor condition of all workers with a new minimum social floor for all employees, because of the platformization of traditional sector. More and more people could be platform. More and more firms could be platforms, and so they can use platform workers statute. And so at the end, that could drive all the employee contracts in towards this minimum social floor. Yeah, it's the same process like you mentioned it, Maja, on the temporary workers. It's exactly the same. At the beginning, it was illegal, and now the agency are legal. And it's the same for the platforms. They were really illegal actors, and they will be legal. We are legalizing the social practices of the platform. I think it's very dangerous, and maybe so that's why it's really not finished with this question of directive, and that we will have to be very fit for the implementation in each country. So, yeah. I was very interested about the presentation about Italy and the different phases, because for me there is a real gap since 2019, and that it's like we are involved in this directive process, and we don't have the possibility to fight at local level.
Is that a question from Emilio then? Anne, are you asking Emilio a question there?
Yes, just the result of the national strikes. What are the results of the national strike of March 2022?
2021.
Sorry.
Yeah, honestly, the strike, I think that was the highest point, in the organization mobilization here in Italy of food delivery riders. Unfortunately, after we saw the decline in their activation and organization, just some days after the strike, Just Eat decided to sign this contract, moving to a employee-based model of organization. So honestly, we were already discussing with the company before the strike. But how to say, it was a process. We arrived to the strike step by step. So it was part of the power that we put on the table during the negotiation, during the bargaining process. So it was part of this. The limit was that after this, it was, there were a decrease in the participation, also because during the negotiation, during the bargaining process with Just Eat, traditional union opposed a formal acknowledgement of the rider per i diritti network. So, for example, this is quite crazy, but Just Eat was in favor to accept rider per i diritti to sign the agreement, while traditional unions did not accept us to sign the agreement. It was quite crazy, but that was the point, because traditional union were trying to defend their role as formal representatives, opposing a real acknowledgement of the role of informal unions, more than companies.
Okay, is there anyone else that wants to have a last comment or question before we finish up? No? Okay, then I'll just say thank you very much to Anne, to Emilio, and to James for your presentations. Thanks to Sindikati Mladi Plus for organising the event, and have a good day. Bye-bye.
Bye-bye.
Bye.
Thank
Good
you very
day.
much.
Have a nice
Bye.
day.
Thank you.
Bye.
Thank you very much.